Ladies and gentlemen, greetings to you all. I am Haribabu, an advocate at High Court for the state of Telangana at Hyderabad. I have started this web series to bring to you the true constitutional content and intent. I am not a teacher of law at any university or any other institution to teach whatever is in practice. Usually teachers do that. If they do otherwise, they lose their jobs. Whereas I am an advocate, a researcher, and a writer of books on Indian Constitution. I wrote a book called Indian Politics versus Indian Constitution in English and Bharata Prajalamu Memu in Telugu and published them through Notion Press, which are available online worldwide on Amazon, Flipkart, Kobo and Notion Press. If I bring the routine content of the Constitution, what we have been witnessing for the last 75 years, there is no purpose of starting this web series. What I am going to tell you is diametrically opposed what has been witnessed during the last 75 years by all of us. I told you that India was neither secular nor socialist nor federal. I told you that election of somebody as chief minister in the assembly or somebody becoming prime minister with majority in the Lok Sabha is not contained in Indian Constitution. It was contained only in Pakistan Constitution under Article 91 and 130. I told you President of India is the only elected executive in India. I also told you that if a person becomes chief minister or prime minister with majority in the Lok Sabha or the assembly, there would be none to question them in the legislatures and there would be none to oppose them in the respective constituencies. So they become unruly, undemocratic. They will oppress and suppress the opposition. That is the characteristic of monarchies, but not of democracy. I told you SR Bommai case was not constitutionally correct. I told you that E.V. Chinnaya case on reservations was not constitutionally correct. I also told you that Keshavananda Bharati case of 1971 was not also constitutionally correct. Today we will discuss about the Keshavananda Bharati case. In this case, the Hon'ble Supreme Court held that Parliament has power to amend the Constitution under Article 368, but it should not destroy the basic structure of the Constitution. My grouse is that the Honorable Court did not spell out precisely what the basic structure of the Constitution is. There is a huge void. Now the legislative and the executive are afraid of making any law lest it should be struck down by the judiciary on the ground that it is against the basic structure of the Constitution. The Honorable Supreme Court held several features of the Constitution as basic structure of the Constitution. The case of Keshavananda Bharati was argued by none other than the greatest advocate, NA Palkiwala, and assisted by a host of legal luminaries such as Fali S Nariman and several others. I only mean to praise their arguing capabilities to get the case done. It is the responsibility of the Supreme Court to be on their guard As advocates, they won case for their client. That is what they are paid for. In my opinion, this judgment destroyed Indian democracy, Indian sovereignty, and Indian constitution as well. Let us consider what the preamble reads. We, the people of India, having solemnly resolved to constitute India into a sovereign democratic republic. Please remember, after this, the conjunction "and" is used. And to secure to its people justice, liberty, equality. We know justice of social, political, and economic, liberty of thought, expression, faith, belief, and worship, and equality of status and of opportunity. This is the second part of the preamble. The third part of the preamble is again "and to promote among them all fraternity, assuring individual dignity and unity of the country." Of course, integrity, socialist and secular, these words were added in 1976 through 42nd Amendment. That's a different issue. In my opinion, sovereign democratic republic is the basic structure of the constitution. In fact, it would have been sufficient for the constitutional framers to say that India shall be a republic, because a republic is always sovereign and always democratic. In the word sovereign democratic republic, republic means a country ruled by an elected or nominated president instead of a monarch, in which people are supreme. So, republic is a noun. Sovereign and democratic are the adjectives that qualify the Republic of India. The rhetoric phrase of sovereign democratic republic has confused Indians, and they perfectly missed the purport of that phrase. This led to misunderstanding, misinterpretation, and misuse of the Constitution over the last 75 years. Just now we studied that sovereign democratic republic is the basic structure of the Constitution. And then to secure to its people justice, liberty, equality is the main objective of the Constitution. Democracy is the process of constructing a sovereign democratic republic. Promoting fraternity, assuring individual dignity and unity of the nation is the ideal. Unfortunately, Indian elite have misunderstood the process of constructing the basic structure, and the ideals or the objectives are that what we can expect from the basic structure, like justice, liberty, equality. These are confused with the very basic structure. Justice, liberty, equality are the objectives which are ideological. Assuring individual dignity, promoting individual dignity is an ideal. We should not get confused between these three. This explanation is better understood if I say construction of a road, railway, bridge or building, their objectives their process of construction are entirely different. We should not be confused with each other. In fact, the court, while stating that the parliament should not destroy basic structure of the constitution, did not precisely spell out what basic structure of the constitution is. Instead, it said that it would be observed only when a case comes for hearing. The Honorable Court, while declaring with the basic structure of the constitution should not be destroyed, unfortunately allowed the basic structure to be sullied, destroyed by opportunistic politicians, either with ignorance or with malevolence. For example, in the place of sovereign democratic republic, socialist and secular were added in 1976 through 42nd Amendment. Hon'ble Supreme Court held in S.R. Bommai case that India was federal. In fact, these three words, socialist, secular and federal, were objected to by the great Dr. Ambedkar in the Constituent Assembly when Mr. K.T. Shah, a socialist, proposed to add these three words into the Constitution. Now let us consider whether what is the power of the Parliament to amend the Constitution. We all know that the Constitution was made by the Constituent Assembly consisting of 299 members. Out of them, about 60 members were not elected people. They were representatives of the princely states. Yet, they were the members of the Constituent Assembly. They participated in drafting the Constitution and passing the Constitution in the Assembly. And they used the word, we the people of India. So the Constitution is made by the people of India and presented unto themselves. So now the people of India are the owners, are the authors of the Constitution. Now who are the representatives of the people? The members of the Parliament. Excepting the 12 members appointed by the President of India to the Rajya Sabha, all are elected by the people, responsible, answerable to the people. As such, they should have power to amend the Constitution as far as practicable and as far as it is conducive to attain the main objectives of the Constitution. We must also understand that Parliament includes President of India under Article 79. So we should understand that Parliament is the sovereign power of India. In fact, Article 368 did not contain any limitations or restrictions on the power of the Parliament to amend the Constitution. Of course, amending the issues covered by Article 54, 55 and issues relating to the High Court, etc., amending them requires the consent of more than 50% of the state assemblies also. To make a constitutional amendment, at least 75% of the total membership of the houses should be present. It would be counted separately for both houses of Parliament. And out of them, more than 2/3 members should agree to the proposed change. It is a very tough process. Constitutional framers, keeping the requirements of the citizens of India, they have given this power to the Parliament. but they have imposed very strict conditions to do that. If we sacrifice the wisdom of 775 parliament members who are responsible to the people, who are elected by the people, and rely on legal knowledge of 3 or 5 Honorable Supreme Court judges, please consider what happens to democracy of this country. We know bills are passed in the parliament by majority vote. Other political parties have the right to oppose the bill. If the bill is passed by brute majority, the opposition is yet free to go to the streets and educate the masses. This is the beauty of democracy. Laws are proposed by one group of parliamentarians, opposed by another group of parliamentarians, and finally people judge the correctness of the law and its implementation. The Honorable Supreme Court ought not to have smashed this democratic process. Let us also consider whose responsibility is this? Who is the custodian of the Constitution? Popularly, we believe that the Honorable Supreme Court is the custodian of the Constitution, but in fact it is not. Please consider the oath of office of the President of India. He takes oath to preserve, protect and defend the Constitution of India and the law, and to devote himself for the service and well-being of the citizens of India. This is the greatest oath. Such oath is prescribed only for the President of India and none else in the country. So it is his responsibility to preserve, protect and defend the Constitution of India and the law. Whereas Honorable Supreme Court judges take oath under Schedule 3 of the Constitution to be truly abide by the Constitution and to uphold the sovereignty of the country. These two words President and governors do not utter in their oath of office because they themselves are the sovereign powers. Honorable Supreme Court judges, having taken oath to be truly abide by the Constitution, should they change the Constitution or its amendments? As such, my humble submission to the elite class of this country, to the listeners in particular, to understand that legislation or making law is a legislative function. Assenting is a executive function. Honorable judges, having taken oath to truly abide by the Constitution and to uphold the sovereignty, if they start striking down the law made by the Parliament, actually it amounts to misbehavior or incompetency under Article 124, Clause 4, and render them liable for impeachment.